Hi, my name's Annie Elisa Mason. I'm from the Bunchline Warrama Purified Dungully Wiradjuri Nations. I'd like to acknowledge the land that you are all standing on today, the Eora Nation and the Gadigal people for the beautiful land that you are standing on today, and give thanks for you all being there today. Thank you and God bless you all.
Hey there, I'm Teddy, ACON's Manager of Trans and Gender Diverse Health Equity, and I'd also like to acknowledge that wherever we are, wherever you're watching this forum, we are in Aboriginal land, and I'd like to pay respects to all elders past, present and emerging, any Aboriginal and or Torres Strait Islanders who are watching this, who are participating in this, and a particular shout out to our sister girls and brother boys who are truly the future.
I'm AJ, my pronouns are they, them, and I'm president of Trans Pride Australia.
And we are so delighted to welcome you to the second panel of our forum series. It's called Trans Rights, Protection and Justice.
Today's part of our Trans Pride during a pandemic. It's a 4-part online forum series for trans and gender diverse people and our allies, with support from the City of Sydney. With COVID, this has changed the playing field for many, and we have discovered on our TPA digital hangouts the vital importance of people keeping together. We are family, we are friends, and some have become lovers.
My very small team at ACON and I recently pulled off something huge. We built Trans Hub, and it's for all trans people in New South Wales, our loved ones, allies, and health providers. And while Trans Hub has lots of the answers to our community's questions, nothing beats a conversation to learn more.
This year hasn't been an easy time for anyone, but with COVID-19, it's been hurting those communities that have already been hurt. We know that many trans and gender diverse people have been having an especially tough time.
So this series was created to help fight back, to provide you with tools and connections to get through, and to flourish as we come out of this pandemic.
For more information and resources, either join one of the Trans Pride Australia community groups. We've got 4 closed groups, one for trans and gender diverse people, one for the allies and friends, a partners group, and a parents and carers group. Or just keep watching today. Don't forget to check out Trans Hub. It's simple to navigate, and there's a link in the chat right now for you to be able to visit. How easy can that be?
Now, with those formalities out of the way, let's pass the mic over to Joel Wilson, who's moderating today's panel. Thank you so much for joining us,
and being with us
have
tonight.
a really beautiful night.
Hi everyone, good evening. My name's Joel, as Teddy said. I use he, him pronouns. I'd like to begin by acknowledging the traditional owners of the lands on which we are meeting tonight and recognise their continuing connection to land, water and culture. This evening, I'm meeting on the lands of the Gadigal people of the Eora Nation, and I encourage you all to pause and reflect on the lands and traditional owners of where you're meeting tonight as we collectively pay respect to their elders present, past and emerging. I extend that respect to all Aboriginal and Torres Strait Islander peoples, in particular to the brother boys and sister girls who are with us tonight. So, welcome to Trans in a Pandemic's second installment, Trans Rights, Protection and Justice. Tonight we have 5 wonderful panelists joining us to share their wisdom and wealth of knowledge on all things legal. Firstly, I'll introduce Jess. Jessica lives and practices law on the Sunshine Coast in Queensland and has been a solicitor for over 12 years. She has a broad experience in law and these days practicing predominantly in property and construction law, advising clients on tax compliance and risk. In her spare time, Jess is a parent to 2 young daughters, and she also sits on the board of Trans Pride Australia, where she provides legal advice and guidance to the board. Evan, if Jess wants to give a wave. Second in line, we have Rebecca. Rebecca lives and works on unceded Gadigal land. They are currently employed at 2010 as a client engagement officer in case management. This involves supporting young people aged 12 to 25 who identify as LGBTQIA+ through housing advocacy, temporary counselling and everyday challenges that people from marginalised communities face. Our third speaker is Ayebatonye. Ayebatonye works part-time at Anti-Discrimination New South Wales as an assistant community engagement officer, focusing on improving services for trans and gender diverse people. and communities. Outside of her work at Anti-Discrimination New South Wales, Ayebatonye is an artist and DJ, as well as being the creative director of a Regular Fit, an arts platform for Black, Brown and people of colour folk. Fourth up, we have Hilary. Hilary is a lawyer and until recently was the principal solicitor at the Inner City Legal Centre, a community legal centre with a statewide practice in LGBTIQ law. Her practice there focused predominantly on criminal defence, trans people and sex workers. Hilary also acted for the applicant on the landmark case re Kelvin, which removed the mandatory requirements for a court application for trans children to access gender-affirming hormones. Fifth, and lucky last, is Ghassan. Ghassan is the legal director at Equality Australia, an organisation working to ensure equality for LGBTIQ plus people and their families. Ghassan has over 10 years experience in LGBTQ advocacy and is the author of works on the legal recognition of same-sex couples and their children, homophobia experienced by same-sex attracted Australians from Arabic-speaking backgrounds, and Australian refugee decisions based on sexual orientation. I'd like to give a big warm welcome to all 5 of our speakers. I'm very excited to hear what they have to say. We had a chat a couple of days ago, and I can only say we're all in for a treat and some like fantastic knowledge and resources amongst these 5 people. So first up, I'm going to throw to Ghassan first, and we'll do a bit of a situation. If I'm going to the doctor or walking into a shop, what are the sorts of things I can be expected to be protected for under the law? Ghassan, what are the sorts of things that we can expect just as everyday people when we go outside into our lives? Oh, you're on mute still.
There we go. Sorry, I couldn't unmute myself. Hi, everyone.
There we go.
Look, across Australia and also in New South Wales, people are protected from discrimination based on their gender identity, and that includes their gender expression. So that means being treated effectively the same as anyone else would be in the same circumstances, and also not being asked to comply with a requirement or policy that's unreasonable. What does that mean? That means that if someone who is not trans and gender diverse is afforded basic dignity and respect, a person who is trans and gender diverse is entitled to that same treatment. So that means addressing you by the correct name and pronoun, allowing you to use a bathroom that accords with your gender, being safe in your workplace, at school, or when you access services like going to the doctor. And on top of that, there's a whole range of other legislation, including privacy legislation that regulates how organisations like government agencies or private organisations use your personal information when they can disclose it, and your right to update it so it's accurate.
Yeah, fabulous. So it's good to know we're afforded, regardless of how we present, we're entitled to kind of be treated how we request to be treated. In the event some of these things might not go to plan, I might throw to Ayebatonye to chat us through what are some of the formal complaint processes and that someone can go through, and why someone might want to go through a formal complaint.
Yeah, sure. Hello, everyone. I'd like to quickly acknowledge that I am streaming to you from Gadigal land. I want to pay my respects to elders past, present and emerging. To answer your question, Joel, I guess if someone might want to go through a formal complaints process, for example, coming to us at Anti-Discrimination New South Wales. So if you don't know what we do, we administer the Anti-Discrimination Act 1977 through inquiries, conciliations, we advise government, among other things. But you might want to go through a formal complaints process because it's a good way to come to a mutual understanding or agreement. It's free. There's some good outcomes that can come through the formal complaints process. I think what is important to note is that it is a fairly long process, and it generally takes around 6 months if you came to us from when the complaint is accepted through to when it is finalized. So I think that's something to take into consideration. But if you want to, I guess, make a formal complaint about discrimination in accordance with either federal or state law, it's a good option and it's free.
Fabulous. Can everyone hear me? Yeah. So in terms of the, we were chatting about this, and I think Hilary might be able to also chime in on this one. With the complaints processes, I'm a data scientist by day. I know nothing in terms of legal matters, but I understand it can be a little bit complex with different pathways. So perhaps you could kind of enlighten us on what are the different pathways that you could take in a complaints process, and why someone might choose a particular one based on whatever outcome they might be seeking.
Yeah, absolutely. So as I mentioned before, you can come to either us or the Australian Human Rights Commission, us being Anti-Discrimination New South Wales. I guess the difference between both of us is that the Australian Human Rights Commission administers laws that cover all of Australia, whereas Anti-Discrimination New South Wales, we only administer law that covers New South Wales. I think that if you were to have a complaint that might be covered by both federal and New South Wales-based law, it might be better for you to lodge your complaint with the Australian Human Rights Commission. And this is because if you were to lodge a complaint with us first, and it was accepted by us, and you wanted to sort of go to the Australian Human Rights Commission to follow it up, that wouldn't be, they may not accept it, not always, but they might not. I think what I would stress is the most important thing in terms of making an informed decision is to call the inquiry line. So the Australian Human Rights Commission has the National Information Service. We have our own inquiry line. They're both free calls that you can make. And basically, the inquiry officers are very well versed in explaining to you what the best path would be for you. They can also take you through to other pathways that might be available. For example, if you need legal support, they might direct you to Legal Aid or the Inner City Legal Centre. Among other sort of things. I think that also it's important to note that if you were to come to us versus the Australian Human Rights Commission, there are different timeframes in place. For example, the Human Rights Commission has a 6-month time limit from when the incident happened, whereas we have a 12-month time limit from when we take a complaint from when the incident happened. There's a few other differences. I've shared some things with ACON that might explain a little bit better how the complaint process itself works, but I'd say those are the key points that I would mention for now. And if anyone else wants to jump in and add something, I will pass it on. Yeah, Hilary.
Yeah, Hilary.
I'd like to chime in. The two processes are really, really similar. So basically,
yeah, that's a good point. Yeah,
investigation, and then there's a mediation, which is someone helping you and the other side to come to some sort of a resolution. So there isn't a third-party decision maker. It's purely based on what sort of agreement you can reach. But then with the Anti-Discrimination Board, if you don't reach a settlement at the conciliation stage, then the next step is NCAT, which has the advantage that people are generally not legally represented. It's quite informal, and the cost risks are pretty minimal. Whereas from the Human Rights Commission, the next step is the federal court. And the federal court may be where you want to end up because you want to make a point about changing the law. So as has been pointed out, if you choose one, you generally can't choose the other. So it's good to get some advice from somewhere like the Inner City Legal Centre to talk through the options and potential consequences before you file your application. And also with this process, you can get money. Most people don't generally get that much money, but you can also get the organisation that you've made the complaint against to engage in training, and you can get non-financial outcomes like an apology. It really depends on what is going to be most meaningful for you.
Absolutely. I think I would also just add to that, if it was taken to federal court, then you would assume costs, and it can be expensive. And yeah, thank you, Hilary, for saying all of that. I think that was all really important. Yeah, I think it's a really good point to be made. So thank you. Oh, sorry, so my executive manager said in the chat, Elizabeth, hello, AD New South Wales, as in Anti-Discrimination New South Wales, doesn't have a time limit for lodging a complaint, but if it is longer than 12 months, then it could be declined unless there is a good reason for the delay. So thank you, Liz, for adding that in.
Thank you. It's a good good point to point everyone towards the chat throughout this discussion. We'll be posting links and resources, and feel free to comment and throw resources in there. Keep an eye on the chat. There's some fantastic resources floating around. Yeah, that's Hilary, you mentioned the Inner City Legal Centre as a place that you could go to get support. That kind of leads nicely into another question surrounding, like, what, as you know, Inner City Legal Centre, what support services are available through there, as well as, like, what are some other services that people can go to reach out and receive support?
So the centre is a community legal centre, similar to legal aid, not the same thing. We are a free service. We provide advice and, sorry, not we, Freudian slip. I'm not still the principal lawyer. They are a free service that provides advice and representation. So they also have a specialist trans and gender diverse legal service that runs a clinic every second Monday. And they give advice in pretty much every area of law other than migration and tenancy. So particularly the discrimination that has been spoken about can also arise in the employment context, and in some cases it might be better for you to make a claim under employment law. So the ICLC can give you advice about that.
Perfect. We've chatted through a lot of legal ways that people can pursue complaints and seek a resolution. We also mentioned, and Rebecca, might be a good point to throw to you. You brought up that there are lots of options, non-legal ways that people can go about resolving disputes, and, like, what are some of those things that we can do, and how can someone get support to seek non-legal resolution?
Yeah, absolutely. Thank you. I have two words: internal complaints. When you're engaging with an organisation or a service, there will always be someone within that organisation or service that would be horrified if your human rights were invalidated. So I would escalate within the organisation itself. Most organisations have a complaints department, and find someone who is willing to listen to your complaint and take it further. I would also recommend social media. Calling people out on social media can be the death of a lot of organisations and services. Like, if you're disrespected in a cafe or a restaurant or something, and they're not willing to take responsibility for that, absolutely hit up social media. And if you don't have the energy for that, because we're talking about things that are really emotionally intensive and very labour intensive, find someone that can push this for you. Find an ally or a cheerleader, and get someone who can bat in your corner.
Yeah, fabulous. Thanks. Thanks, Rebecca. We've just had a really good question. What about services? So, Hilary, you mentioned services in Sydney. What's available, and this might be one to throw to the wider group, what's available in rural and remote areas? We've got a lot of Sydney-based resources, but how can someone reach out and get help when they're not so close?
There are legal centres that cover the whole of New South Wales. So if you go to, I'll put it in the chat, clcnewsouthwales.org.au, you can find what your local CLC is, and you can get some free legal advice from them. Also, a lot of legal aid offices will have a drop-in clinic where you can get some advice.
Perfect.
Just to add to that, Anti-Discrimination New South Wales covers all of New South Wales. So you can call our inquiries line no matter where you're dialing from. We can assist.
Perfect. Rebecca, I'm going to throw to you again. We're talking about a lot of complaints processes, and these have big impacts on our well-being and our resilience and our euphoria. What are some? You had some great suggestions the other day about things that people can do to really make sure that they get through a process of raising a complaint. What are some things that people can do?
Yeah, absolutely. So I think starting with your inner circle or your support bubble is a really good place to get that initial support. Sometimes you just want to vent, and that can make you feel a bit better about the situation that you've experienced or the discrimination you've experienced. I think anytime that your euphoria or resilience is tested or starting to feel depleted, you can start to turn to services such as 2010, ICLC. You can always find someone to advocate on your behalf if you're struggling to find that energy to keep going in that situation.
Yeah, great tips. I love the finding a champion. So finding that person that really gets along beside you and can kind of help you. It's really, really important.
Absolutely, make the allies do the work for you.
Yeah. Often it can be a burden that we all pick up, and reaching out and making sure that you do reach out in that process, because it can be quite long. Fantastic advice. I'm gonna more broadly to all of you, Jess, I don't know if you'd like to start this one off. We had a few questions come through from the audience prior. Interested in kind of hearing what are your thoughts on what the most pressing law reform is needed to enable greater protection and justice for trans folk. Does anyone who would like to start on this one?
I'll have a start, and I actually don't think it's just a gender issue. I think it's the way society is moving with certainly the online space. I think the government needs to do a lot more in that space, particularly with children accessing the internet. So as a general issue, it's something they need to deal with, and it's certainly pressing for people dealing with gender identity.
Yeah, fabulous. Who else has thoughts on this one? What is the most important thing that needs to kind of be pushed in the law?
I hesitate to say the most important thing, but the really, really important thing would be to reform the law about birth certificates in New South Wales, because the current law, which is that you have to have had surgery before you can change your sex on your birth certificate if you were born in New South Wales, is completely barbaric and is not in keeping with the reforms that have happened in other states of New South Wales. And people are usually really understandably confused and upset when I tell them what the current law is. So I hope that will be changed very soon.
Us Queenslanders agree wholeheartedly with that.
And I saw a question.
We have the same issue.
Sorry, and I saw someone is on from WA, and there's similar challenges, not quite as, because of a High Court case, not quite as a problem in terms of surgery requirements in WA, but those are the 3 states where birth certificate reforms are still needed. But, on top of that, there's a range of areas that reform legally could assist people, but there's also a range of areas where, beyond law reform, programs, social programs that we know, for example, unemployment rates, mental health, family and domestic violence, and governments have a huge role in delivering services or engaging others to deliver services. So discrimination laws where there may be exemptions, for example, for certain organisations like faith-based organisations, making sure that the laws apply to everyone equally and that there are no exceptions in terms of treating people unfairly because of their gender identity.
Ayebatonye, do you have, or Rebecca, do you have any thoughts on this question?
I think I'm going to respectfully decline answering this question. I think a lot of great points have been made. So I'm not a legal expert, so I don't want to,
Absolutely fair, absolutely fair.
I'm also not a legal expert, and I really respect everything that everyone has said, but having supported lots of folks to update their birth certificate, I can definitely agree with Hilary that is a huge barrier that people come up against, and constantly being dead named when they have a legal birth certificate, and it not aligning with their gender is Yes, awful.
Yeah, that was something, that's a good point that we discussed before. What in terms of someone's right, if I have a birth certificate that doesn't align with my identity and the name and pronouns that I use, what are my rights in terms of being able to request confidentiality? So if I am admitted to a hospital and my records might have one name, but I request to be addressed as a certain my name, what are my rights? What can I expect?
I'm happy to answer that. If that's so, the laws that protect against discrimination Australia-wide, they don't require a change of birth certificate. They require the person to treat you fairly and without discrimination, regardless of what your legal, gender marker is. It's based on the gender that you are, and so you can request from the hospital or the clinic or your practitioner the name you wish to be referred by, the pronoun, and if that isn't complied with, that can in itself be discrimination, because they would afford that same dignity to anyone that says, well, my marital status is Mrs. or a Ms. or whatever. So, it's all very similar in that way. In terms of other areas, so that's just in discrimination, but people can also update their Medicare card without any surgery requirement. So you can actually update, for example, your passport and Medicare cards, and the federal government has a policy around that, which requires effectively a stat check, or in some cases, and it's more of an affirmation approach and less of a surgery requirement like we have in the birth certificate laws. So you can hop online. Hilary's already posted it. Amazing. So there is actually more support for changing some documentation at the federal level, like a passport or a Medicare card. And as I mentioned, a lot of these organizations have privacy obligations. So if someone is disclosing your trans experience, that's a big no-no. If they've done that without your consent in particular, or to someone that you didn't give them permission to. So there's protections in that space. So updating your documents or your details with, say, a bank or your doctor shouldn't be anything more than calling up, asking for that to happen. They might require some kind of proof of identity, but they might not. And if they do, for example, a driver's license in New South Wales doesn't have a gender marker on it, Medicare cards can be updated. So, and for the most part, if they fail to do that, it could be discrimination in and of itself. So, again, there's, engage in those internal ways of complaints, because sometimes the person you deal with immediately might not really have the ability to change things, or even, experience or knowledge of these issues, but that doesn't mean that the law's not behind you.
I'd just like to add one small thing to that, which is with roads and maritime services in New South Wales, it's completely correct that there's no marker on the driver's license, but there is a sex marker on your record with RMS, which you can get changed with proof that's very similar to the passport. You don't have to go through the birth certificate bullshit.
How I wish I'd known all of this when I was changing all of my documents. Fabulous, great, really, really great information. I'd like to change direction a little bit, and let's, particularly topical at the moment, let's talk about under 18s rights. How do these rights and protections under the Anti-Discrimination Act apply to under 18s who might be in school and whatnot, and faith-based schools and all of those sorts of things? What are our rights for our young trans and gender diverse people?
I'll start there, and Hilary, I'll jump in whenever. Look, generally the protections on discrimination based on gender identity are age neutral. So it doesn't matter if you are under 18 or over 18. If you're discriminated on the basis of your gender identity, it can be unlawful. there are some exceptions, and in New South Wales, one of the biggest ones is for private schools. So there are some exceptions, and then there's some exemptions for faith-based organisations as well at the federal level. But all schools have a duty to the students that go there in terms of their welfare. So apart from discrimination laws, there are other laws in general obligations that exist to protect the welfare of that child. So while the law isn't always great around some of these issues, it doesn't necessarily mean that there isn't a law elsewhere that will protect you. And ultimately, it's again the same process of seeking allies, speaking to, well, if parents are able to assist in this process, speaking to trusted people within the school. And most schools, regardless of the legal obligations that place on them, will talk with the parents and the child about the best way for managing the affirmation of a gender in terms of uniforms, in terms of preparing the class and those sorts of things to help that process happen in a way that's most conducive to the child's welfare.
And just picking up a little bit on what you've said and following on from something Rebecca said earlier, even if the discrimination protections aren't there, it's still possible to pursue a young person's rights in a non-legal way. So by speaking to the principal, by advocating for them within the school. And as has been pointed out, schools have a duty of care to take care of their students, and it doesn't matter whether you're a religious or a state school for that to apply. In New South Wales Department of Education schools, the way that the schools are supposed to deal with trans kids is dealt with by a document called Bulletin 55, which I will put into the chat right now. And that can be really helpful for parents in advocating with the schools, because sometimes it can just be that the person at a school doesn't really know what they're supposed to do. They're not really experienced in dealing with these issues, so they may not necessarily be transphobic. They could just not know how to take that next step. So the information in Bulletin 55 is really helpful for that.
Yeah, great. Thanks, Hilary. I might, Ghassan, you had a great comment that limitations in the law do not mean limitations in outcomes, and you were talking about how there might be those exemptions, but that there can be other laws that still cover you. What did you? Can you elaborate on that?
Well, certainly other laws can cover you. So, for example, consumer laws can apply, or privacy legislation, or just general obligations that people in positions of responsibility for others have duties to each other. So, and also the whole gamut of professions. So, doctors and psychologists and pharmacists are all regulated by obligations that apply. So, when they don't treat people with respect in the way that they deliver their services, there's a board for doctors and a board for lawyers, and there's all this plethora of kind of structures that can provide protection where the discrimination laws have holes in them. But also, as notwithstanding I'm a lawyer, people don't have to only rely on the law, and everyone should feel like their agency is not just defined by what the letter of the law says that they're worth. At the end of the day, if you're an employee, you're valuable because you're an employee to that place. If you're a customer, you're valuable because you're a customer, a client, or a patient to that place. So voting with your feet, raising a ruckus, getting someone to help raise a ruckus for you, organisations are worried about reputational harm. Doctors and others are worried about keeping their licenses to practice. And businesses and organisations are also worried about the bottom line. So think creatively and don't just limit yourself by what someone else tells you in some law, written by some old white guy. is your worth.
That's a great point. We all have power in different ways in the different places that we exist. Share with your networks. That's a great point. We've had a really good point from the audience. What about those of our community who are non-binary? What rights do they currently have in terms of changing their markers to perhaps X in different documents, from passports to our government systems, as well as maybe in a non-government system? What are their rights to be recognised in their identity?
I'm happy to give some of that, but Hilary, you probably, and others probably have some insights as well. In terms of discrimination law, gender identity protections exist and protect people who are non-binary. So it's not just for trans people, but people who don't identify as either male or female, or are genderqueer and other identities. In some states and territories, you can actually change your gender marker as well to express non-binary identities. That's not the case everywhere, and it does vary from state to state, so it's a bit complicated to go into that. But a lot of federal, or like your passport, for example, or Medicare card, and documents that federal government provide do give options around an X marker, for example. And unfortunately, this is part of the issue, is it's the complexity of trying to navigate all these systems. But when in doubt, look at any documents or policies that particular organisation might put out. But generally at the federal level, there is actually a policy about an X marker being an option. Unfortunately, the discrimination protections do include exemptions for people in terms of record keeping that doesn't necessarily always require non-male or female gender markers. But again, banks, big organizations are well ahead of where the law is in terms of what is required, and many organizations will honor your own desire to change your markers without requiring any sort of legal process.
I obviously agree with all of that. And also to clarify, unfortunately, the requirement for non-binary people with their birth certificate in New South Wales is the same as for binary identifying people. Surgery is still a requirement.
Fantastic. We've also had some questions regarding, and I think, Ghassan, you might have covered this off earlier, regarding a person's right to actually be socially affirmed. So just to reiterate that, where people are asking, are they allowed to ask people to use their new name, or to wear the clothes that they want, or for someone to use affirming pronouns? So we've talked a lot about the legal documentation, but sometimes it's actually about being able to, knowing that you're able to just be yourself and that be respected.
In the broadest general way, yes. So the laws that protect against discrimination don't require you to have changed any legal marker. They don't require you to have undertaken any form of medical affirmation, hormone treatment or surgery or anything like that. So however feels right for you in terms of dress, in terms of the name, unless there's a legal reason, like you have to sign a witness document and then you have to swear some sort of thing as to what your legal name is or something like that. But apart from those sort of very isolated things where what your legal name is or what a legal gender marker is, for the most part, the law doesn't require, and the laws protect, in fact, people being able to use the name that they wish to go by. Obviously, there's formal processes when identity checks are done and that sort of thing that can be much more confronting and difficult for people. But I think if in doubt, speak to ICLC or or another service like that about those specific scenarios?
I think that's a really interesting point. It's not illegal to use an alias name. It just becomes an issue in dealing with government departments. And there's a number of cases over many decades where people have signed, people call me Jess, names are shortened, and that's a social reason. But the courts have actually found that persons entering into contracts under alias names have been bound by those contracts as well. Obviously, there's no government policy or anything around the formation of a contract, so it's simply proving is the person generally known as that name.
Perfect. In terms of our when we're going into services and using our names and having that respected, there's some resources that are out there. And Teddy, I don't know if you're online, but Teddy with TransHub has got a fantastic resource of a little card that you can take along with you to your doctor to help that you can pre-fill out and take with you, so that any doctors that are seeing you can kind of have that and know from the get-go, and it makes it easier rather than verbalizing. So hopefully we'll post that in the link, because that's a fantastic resource if you're in need. Okay, you guys, you're all answering very succinctly. The 5 panelists got the brief that they had to answer very succinctly, and they've flown through the questions. Let's move on. Let's move on to some myth. We discussed a little bit of myth busting. So things that people can ask us and can't ask us. And what are those contexts that people can ask us questions? And when is it okay or not okay? Who would like to start?
I can start. I'm not going to be comprehensive, but police officers in certain circumstances have the power to ask you for your name and ID. And that's a very, very big can of worms I've just opened with that statement. One thing that I wanted to touch on as well, we're talking about complaints. Police complaints are a really important thing to do. I am generally pretty skeptical about making police complaints, because they tend to find that they've acted appropriately, shockingly. But if people don't make complaints, then it's too easy for them to pretend that the problems don't exist. So if people feel safe to do so, it's really important to go on the record when police have done the wrong thing.
In terms of asking questions as well, the federal discrimination laws, in fact, have some protections around the asking of questions. And again, privacy laws may protect the information that you've disclosed that's personal to you. Generally speaking, unless there's a legal reason why they'd be asking you a question about any of your trans experience or gender identity, it's frankly none of their business, and that should be your response, unless there's some legal compulsion that requires them to provide you for you to provide that information. It's no one's business but your own.
One context where it can come up is criminal records checks in the context of employment. In other jurisdictions, like in England, there is a facility for a sensitive records check, where the criminal records check can be made and come back as clean, but not notify the recipient of previous names used. Unfortunately, we don't have a similar facility in New South Wales. But something I have often told clients with asking questions or being asked questions is there's nothing wrong with a dumb, curious response of, well, why are you asking me that? Because that can often take people aback and make them think of the necessity of asking that question.
Ayebatonye, you mentioned earlier that there are some perhaps flaws or things in the complaints process that are lacking. And I was wondering if you could elaborate on some of those things so that people, if they do decide to go through a complaints process at any point, that they're kind of aware of some of the things in the system that don't necessarily accommodate for trans and gender diverse people.
Yeah, so I think it's really important to note, like, before I say anything, that all of us at Anti-Discrimination New South Wales recognize that a lot of the language that is used within the Act is quite outdated. And yeah, there's a lot of things that could potentially be different. I think in terms of the process itself, yeah, like I said, I think the best thing to do is to make an informed decision is to try to contact the inquiry lines, as they'd be best placed to advise you on where would be best to go. I think what is really important is that it is a long process. Like, as I said, it takes about 6 months for your complaint to go from being accepted, if it is accepted, because there is a chance that it could be declined if it doesn't fit, doesn't work to our Act. Yeah, just bearing that in mind, and that you may feel re-traumatized in having to, you know, sort of revisit this experience of discrimination that you're making a complaint about. Yeah, and there are some laws that we might cover that, for example, I mean, there are some laws that Australian human rights covers that we don't cover. And I also think it's really important to note that, for example, when it comes to trans and gender diverse, we cover explicitly trans people within our legislation, which can be confusing. At the end of the day, we try to just apply best practice, and we understand that no matter how you affirm your gender, you're welcome to come to us, but we still do have to work within the confines of legislation that was written quite a while ago. It's not to say that there isn't work being done behind the scenes to try to change this and make sure our services are more gender affirming and inclusive, but we do have a bit of a ways to go. I think, yeah, I started this trans engagement strategy that I've been working on last year. So, you know, it's going to be a slower process to get to where we want to get to, but we're doing our best. And yeah, I think just feel free to call if you have any questions, but understand that it may not be the process that you might have thought it would be. And as I said, I've shared some things with ACON, so they can share them with you, as with Teddy. Yeah, so you can find out more, but I hope that answers the question in a way. I think you're muted, John.
I just muted myself. You'd think I'd be good at this by now, but I'm not, alas. We've got a question regarding the Imogen case and kind of information surrounding that. Does anyone have? Would anyone like to comment on that one? Am I still muted?
No, sorry. I just wasn't sure whether I had muted or unmuted myself. So the Imogen case is a recent family court decision where there was a dispute between parents about whether or not a trans girl should be able to start on gender affirming treatment on estrogen. And there was a competition of the evidence about whether it was in the child's best interest. And the mother was resistant to the treatment and tried to, essentially in the case, tried to argue that gender dysphoria and trans identity isn't really a thing, and that there's no evidence base for gender affirming healthcare. The court, and I'm covering the positives, I'll get to the negatives in a second. The positive result was that the court very conclusively said that the evidence base for gender affirming healthcare may be relatively limited, but it is there and it is developing. And there is no evidence base for exploratory psychotherapy, which was the alternative treatment that was proposed. So it was a victory for common sense and medicine. The context of this decision was that after the decision in Re Jamie and after the decision in Re Kelvin, which were two full court decisions about blockers and about estrogen and testosterone, there was a bit of a gap in the law about what the situation was where there was a dispute between parents. And the outcome of this was that the court has said that before commencing treatment for a person under the age of 18, the medical practitioner must establish whether there is parental consent. And if there is not parental agreement about the treatment, the diagnosis, or the child's competence to consent, then it's necessary to go to court. And if the dispute is about whether the child understands the treatment and can give their own consent, and only that, then the court will make a finding of fact based on the evidence about whether they're competent to give their own consent. And if that's the case, there'll be that declaration, and then the court has no further role. If there is also a dispute about the diagnosis of gender dysphoria or whether or the form of the treatment, then the court will consider the evidence and determine whether it should proceed with the best interest of the child at the forefront.
Yeah, fantastic. Thank you for explaining that, Hilary. Sometimes, for those of us who aren't in the legal field, it can often be a little bit flummoxing that by the information and what the implications are of these rulings. So
that's because we forget how to talk like actual people.
Look, I working in tech, I find the same thing when talking about tech. No, that's very, very interesting. Good news that common sense prevailed, although acknowledging that there's still a way to go.
Sorry, just to add one more thing, I don't think I covered very well. Where this is potentially a problem is the requirement for evidence of consent rather than lack of evidence of opposition by a parent. But this decision was also a decision of just one judge of the family court, so it is open to another judge of the family court to conclude differently.
Yeah, beautiful. I'm conscious our hour's almost up. Let's just do a quick whip around. What would be your one piece of advice for someone who encounters a situation that they do need to raise a complaint, whether that be legally or non-legally? What would be your service? What's your piece of advice for someone who's not got a legal background in how they can navigate that?
My piece of advice is that you're not by yourself. There are legal services, there are support circles, there are people in the community who will back you. You don't have to deal with it by yourself. And also, you may choose that you don't want to deal with it. You may choose that you want to spend your energy doing other things.
Yeah. Ayebatonye, what would you suggest?
Well, it would be remiss of me to not mention that you should call the Anti-Discrimination New South Wales inquiry line. So it is a free and anonymous service. I absolutely agree with everything that Hilary said as well. Like, at the end of the day, if you don't feel comfortable following through with a complaint, that's completely understandable. But at least in terms of understanding what your options are in a free and confidential way, you can call our inquiries line, and that may help.
Jess, what would you say to our listeners?
A little bit of a similar theme. I always say to people, make an informed decision and don't just seek one opinion, seek multiple opinions. Often we don't know what's best for us sometimes, so it's good to get other people involved in our life that we trust and organisations that we trust. There are people that are probably much smarter than us in making our own decisions, and organisations that can give us that information. So just reach out to them. There's plenty there, and as Hilary said before, there's even organisations that will help with referrals, particularly in the law, in pointing you to the right community legal centre, or some centres will do telephone if you're rural, so they can help you out. Just ask the questions and they'll be more than happy to help you out.
Thanks, Jess. Rebecca?
Couldn't unmute myself there. Do your research and find people to support you. If you're between 12 and 25 in New South Wales, you can come to 2010. If you want some advice or you just want to vent, you can call Q Life anywhere in Australia. You're not alone and you're valid.
Great advice. And as Rebecca said, find your champion. And lucky last, Ghassan, any words of wisdom?
I'd reiterate everything May said, but if you are thinking about taking some kind of complaint, 2 things that a lawyer will always tell you is get it in writing. So if you are treated poorly and it's happened through something that someone has done or said to you, make a note of it, when it happened, what time, what they said, what you said back, where it happened, the key who, what, where, whys, yeah? And if you can, ask for the reason or the thing to be put in writing, because that can be useful evidence that if you make a complaint, you can, especially if the note is made very soon after or close to the event that happened, that can be used as evidence in support of what happened.
Fantastic advice. Thank you all for sharing your vast knowledge base with us, sharing the pointers and how we can access our rights and what we're entitled to under the law. That brings us to the end of tonight's session. If you haven't already, sign up for the remaining 2 webinars in the forum series. Also, don't forget to check out the chat throughout the event. There have been lots of people posting resources and links. Fabulous Teddy and Liz sitting in the background posting a lot of things. Check them out. Sign up for the series, and thank you everyone for attending. An enormous thank you to our panelists. This has been fabulous and incredibly informative, and knowledge is power. And you've helped give our community the knowledge so that we can go out and in the world knowing that we are allowed and able to be proud and who we are. So thank you very much. Thank you, everyone.
Thank you.